Alright guys, so welcome back to another lesson of chapter 2 of law of contracts. This is the second lesson and the last lesson of this chapter 2. So I'm gonna go with the continue of this lesson. For previously I've explained about the laws, what is the Roman Dutch law, the contracts, and how does English law involve in it, and discuss about acceptance of acceptance, invitation to trade, things like that. And finally, so we're coming to the lesson number, the ninth part, which is laetio enormis. So it's in pronounced as a Roman Dutch law, but if it's translated to English, it means enormous loss or enormous prejudice. So uh, this law actually only exists in Roman Dutch law. So if the countries who practice Roman Dutch law has this law, but in common law it is not. So so the principle of is actually very simple. Is that there's a classic example that A sell his land to B for 1 million. Subsequently, A discovers that the market value of this land is about 10 million, and since he has made a genuine mistake after fixing a selling price at 1 million, so there's an enormous loss of 9 million rupees. So therefore A has right to seek relief from courts on the grounds of laetio enormis. So which is actually a really interesting law. That is, so you have to be careful when you're selling a land or a vehicle or any some sort of a property, that you have to sell it to the modern, what you call the modern value. So you can look at in the website, such as place like Daraz, Ikman.lk. You can just look like a roughly idea of what sort of market value is going on. You can sell it for a much more lower, a bit of lower, a bit more higher. It's up to you. But if there's an enormous loss in your side, you have, or that the other party has a right to go to court to ask for a much more compensation and more money from you. So it's actually kind of interesting, and there are ways that this enormous loss is not apply, is where the price is fixed deliberately low out of affection, where the sale is by court, which means in liquidation cases, where the party suffering the loss was fully aware of the true value, and but you just instead kept selling because of you have an urgent need of money, and where the party waives the option to contest. So it's quite interesting. Just go through with the theory and understand it. It's very simple, and this goes to be the types of illegal contracts. So uh, so there are two types of contracts, way to show that a contract is illegal, either by statute or by common law. So illegal by statute means so what is the law is written, so you do it the other way around, such as selling drugs, illegal alcohol, things like that. And under common law, a contract is made by crime, to commit a crime, such as steal things, that sort of a contract. Promote sexual immorality, such as in Sri Lanka, if you caught making porn, especially child porn, make a contract, so that's considered as illegal. Promotes corruption in public life, prejudicial to proper administration of justice. So that means, recently the Ranjan Ramanayaka's case. So that was it's actually a classic example that he said that the judges are corrupted but he tried to emphasize that he didn't say it's the justice, the judges, the court judges are corrupt. It's just some judges are somewhere else. So yeah, contracts like that is now it's prohibited. Contracts of defraud revenue, and contracts related to threat of national security, such as carrying out terrorism, terrorist activities, and making public nuisances, or making riots and things like that. Yeah, so contracts relating to things so extra curriculum, no commercial value, sea shores, rivers, streams, and etc. So contracts related to damaging the environment is also prohibited under common law. And if you want to terminate or discharge of your contract, there are 5 ground rules. So I'm talking about a valid contract, a valid legal contract. If you want to terminate or discharge, there are certain rules: by performance agreement, giving notice, either or breach, or by operation of law. So these 5 categories, one of at least categories, it has to be one or more. You can discharge or terminate a contract. So let's go to by performance. That means you have performed your well, and you got the salary, you got the target, sale target that you included, and then by the time you just discharge the contract and you move on, or you extend to another contract. It depends on the time for performances. If there's like a limited time that is involved, and there's a case that is related to that as well. And the place, the performance, partial of performance is also has to be justified in order to discharge or terminate the contract. And also by agreement. So release or waiver, compromise, and no motion. If you say release or waiver, it is a discharge of an obligation or one party to contract, either gratuitously or for value. So you just pay off or just move on with the contract. So things like that in order to release, or you just give it to someone else. So compromise is for an agreement to be described as a compromise. Each party must recede from his previous position and concede something by diminishing his claim and increasing his liability. Yeah, so that's also another case. So just go ahead with it and read it and try to understand the situation here. And the novation, the creation of a fresh contract, extinguishing and replacing an existing contract. So yeah, quite simple, but actually the theory is quite bit graspy. So it says novation of paper, substitution of a new debt of an existing debt, and there's 2 cases: AG versus Pereira, Amasuri versus Hilarious, delegation, cession, assignment. So these things, and there's a classic example: discharge by agreement. It says that X and Y entered into a contract where X agrees to supply lunch packets to Y on daily basis 5 months. After 2 months of supply, they both agree through another contract to terminate the first contract. In this situation, the first contract stand terminated and discharged. So those things, it's quite easy. So termination by notice. So notice you have to, so the notice has to be communicated in a nice way, and it has to be received by the other party in order to reach so it can be, so the termination by notice, it can be depends on the contracts that you have made, such as if it's as an employment contract, minimum employment contract in order to terminate your position, or you have to resign. You have to give like at least a 1 month period of notice if you are full time. But if you are not full time, you can actually move on anytime you want, and sometimes and after that they will pay you. So yeah, it depends on the contract, how what is the notice period is. Sometimes it's immediate, sometimes 1 week, 1 month, things like that. and by a breach of a contract. So like I said before, breach of a condition and a warranty, it can be anticipated to terminate, discharge the contract itself. So that's called anticipatory breach, and so in that, and an actual breach. So an actual breach is actual violation or failure to perform the obligation. Anticipatory breach is that was party to the contract declares his intention of not performing the contract before the actual time of the performance arrives. So it's called so repudiation and anticipatory, or an anticipatory breach. So in the anticipatory breach, there's a quite a classic example and a case as well. Feel free to research it, and also known as by the operation of law. So said a set of compensatio, merger, confusio, insolvency, like I said before, liquidation, prescription, that means limitations, impossibility of performance, frustration between parties or the board that cannot get through to a better deal, the judgment made by the courts, or death of the other party. Yeah, so places like that, you can by law, it will be where legally this can be able to discharge the contract. So yeah, these are the sorry good thing. Uh, sorry. I got, yeah. So back. So there are some few things for you to read. Please go ahead with it, and in future we will be having seminars. Feel free to ask any sort of questions regarding that, but this is a theory lesson. Just go through it. Everything is quite simple. Answer, just go ahead with it. And so, remedies for breach of contracts. So, remedies, things has to be granted by the courts or some sort of arbitration deal. So, if there's some sort of a breach, things like that, you have to see the consequences of the breach and what sort of a damage that has been occurred in order to claim a compensation from the other party. And but if the price you're asking, the claim that you're asking is over exaggerating, that means overpricing, they can actually negotiate that it's too pricey, too costly. This is an actual what you claim, the actual damage that we are planning to pay. So it can be in the arbitration, through mediation, or through by courts. So in order to claim damages, in contract law, the objective purpose of awarding damages to the aggravated party to place possession issue would be the contract has been performed. Yeah. So the claim of the damage is considered as a substitute to the performance of the contract. So there are, one thing we need to make sure that there are few Latin words. To sue on quantum meruit. So quantum meruit means as much as entered or deserved. So there are few Latin phrases, meanings. So in the exam, in the MCQs, I will be asking at least 10 um, meanings of Latin words, phrases, what are actually their means are. So please do remember this. These are actually necessary for your exams. And moving on, so which also specific performances. Specific performances is that A trying to convince B to do the performance. So when A has done their part, B couldn't, and B so A sued B to do the part of the job properly. That means specific performances. If the B refuse to do so, they can discharge contract by wrapping up the business, and also sometimes A can sue the B for the damages that they have occurred. So these are the list, and feel free to do so. You can also sue by injunction. That means to stop of what is doing that is going away from the contract itself. And yeah, so repudiation. That I have contract. So repudiation of a contract means a refusal to perform duty and obligation over to the other party. Yeah. So the B repudiate the contract. That means he's not performing. So he can actually so impliedly the A, which is the innocent party, can sue it. And also rescission. Therefore, the contract rescission refused to terminate or cancel the contract. The word rescission comes from the word resigned, which is cancel or annul. The purpose of contract rescission is to restore the parties their original status before the contract was made. Status quo ante. See, it's quite simple. So restitutio in integrum. So restitution is available not only for the purpose restoring innocent party to the position they would have enjoyed entered into a contract. It is also general remedy or restoration on status quo ante. So this also means that when A and B working towards and some loss happened, some sort of frustration going on, they can't come to a decision. They come back to the performing stage, planning stage. So what went wrong? They're planning to start from the beginning. So they can continue with the old contract, or they can go on to a new contract itself. And so yeah, to seek relief under principle and unjust enrichment. So the principle of unjust